Sir. Or you might be find some of the fine below that too, sir, if you are first-time offender, sir. Sir, but then they had a surge in offenses in relation to firearms, and the Attorney General at the time, Sir David Simmons, came to Parliament and amended the Firearms Act and moved the jurisdiction, sir, out of the magistrate to High Court, sir. It is my view, sir, that amendment, sir, resulted at the time in a reduction, sir, in firearm offenses, sir, because they had strict penalties. You had to apply, sir, to a High Court for bail. In fact, sir, before, sir, the magistrate could give you bail at low court. Imagine that, sir, that you didn't have to go to your office and prepare affidavits, go to the prison, sir, and get affidavit signed, and charge a fee, sir, that is commensurate, sir, with your High Court appearances, sir. So that legislation, sir, that amendment moved bail applications from Magistrates Court to the High Court for firearm offenses, sir. And, sir, we have seen amendments to the Firearms Act recently, sir. Many amendments, sir. Amendments, sir, that even if you're a first offender and you get caught and convicted on another firearm-related offense, sir, there's an increase and a starting point, sir, in sentencing that is at a higher range than a first-time offender, sir. Irregardless, respectfully, sir, of the mitigating factors, sir, but that would be indeed an aggravating factor that would outweigh the mitigating factors, sir, of a first-time offender, sir. Sir, but it is the learning, sir, what Sir David Simmons said at the time, sir, in the case, sir. I will make this a document, sir. He said, there is no right for ordinary citizens in Barbados to bear arms. It has been totally against the culture and social norms of this country for persons to have and use unlicensed firearms. Possession of a firearm is only legal if the holder has a valid license enabling him to use and to carry it, sir. Firearms, even imitation, he said, firearms endanger a sense of fear in citizens, and their fear of crime is heightened, and sometimes to the point of hysteria. That's what Sir David Simmons said at the time, sir. The background to this, sir, the background to the establishment, sir, of a gun court, sir, in Barbados, or the firearms division, sir, it was indeed a manifesto pledge, sir. The fact, too, sir, that before that, we had an increase in judges and an increase in prosecutors, sir. The fact, too, sir, that we have to staff this court. The fact, too, sir, is that this court is being established to deal not only with the backlog of firearm cases, but also to deal, sir, with the present, sir, cases from January, sir. Persons who have been charged with possession of firearms and charged with various offenses under the Firearms Act, sir. Sir, the difference, sir, between the establishment of a firearm division, sir, and the Jamaica gun court, sir, is that in Jamaica, all trials are held before the jury, sir. So, the accused at the time, or during the matters in Jamaica, sir, gun court, do not have the option of a jury trial, sir, of a jury trial. The difference here in this, the difference in this bill, sir, is that it gives the accused man an option for trial by jury, sir. And it also gives the option to, sir, based on the law that was passed, to a trial before the jury. You can opt, sir, to a judge alone trial. So we must ask ourselves, sir, why this gun court, sir? And I want to state, sir, that out of the 23 murders that we've had for the year, sir, so out of the 27 murders that we've had for the year, the use of firearms, sir, was used in 23 of those murders, sir. And that is also a cause for concern, sir. Sir, I can tell you, sir, that some people might ask me, setting up 2 courts. How are we going to get these courts, sir, operational, sir? How are we going to get them operational, sir? People might ask, sir, do you have cases ready, sir, to start the gun court, sir? But I can report to you, Mr. Speaker, I can report to you, I just want to go through the cases, sir, and the cases and also the cases that are ready for trial, sir. Sir, it's a fact, sir, that the problem, sir, within the criminal court system, criminal justice system, sir, is case management, sir. And having cases ready, sir. And I can tell you, sir, that with the work, sir, of a consultant working along with the police, sir, that at the end of January, sir, 672 files have been submitted to police prosecutors, sir. It is impressive, sir, because it means that we have cleared 21%, sir, of the backlog of cases between 2022 and 2024, sir. As compared to 2025, sir, we only had a small percentage, sir, of 10% of the files being submitted, sir. The files, sir, that are related to firearm offenses, sir, they are being pushed so that we can have, sir, that when the gun court is ready, sir, and I believe, sir, it should be ready shortly, that they will have matters ready, sir, for the court, sir, to be operational, sir. And if we may report to you, sir, of the disclosures, sir, in relation of statements that are ready from January this year, because one court, sir, there are two gun courts that we're establishing. One gun court, sir, will deal with matters from January this year, and the other court, sir, will deal with the backlog, sir. So if I report to you, sir, if I may report to you, in January, sir, you had 4 cases involved firearms, sir, and those 4 cases are ready, sir. Disclosures serve on the accused, and disclosures serve, sir, on the defense, sir. The cases for February, sir, and this is work, sir, along, sir, with the consultant, sir, and the police prosecutors, sir, and getting cases ready, sir. I can tell you, sir, in February, sir, there are 4 cases that were submitted and ready, sir. Disclosure ready, sir. In March, too, sir, we have about 3 cases that are ready and 3 persons, in relation to 3 persons that were charged, disclosure ready, sir. In April, sir, 11 cases, and those 11 cases are ready, sir. With respect to May, sir, we have these 5 persons charged and disclosure is ready, sir. So when they say, sir, disclosure ready, and what we mean, sir, as you will know, sir, that statements are ready and that all have to be done once they're served on the defense or the accused mouth is unrepresented. It means, sir, the case is ready. All the magistrate have to do is commit it, sir, to the High Court. DPP then, sir, will then draft the indictment, serve it on the accused, serve it on the defense, bring down the guy if he's on remand, serve him, and arraign him for trial to start the trial, sir. So we have all these cases ready to, I will use the term, to feed the gun court, sir, as soon as established, sir, to feed it, sir. Because it can't be a court, sir, sitting down idle. Can't be a court sitting down idle, sir. Cannot be. And so I want to really applaud the work, sir, of the consultant, sir. I won't call the name, but indeed, that is good work, sir. And even before, sir, I came here, even before when I was in another place, that I mean, sir, the law courts, I recognize that there was a marked improvement by the Barbados Police Service in serving statements and getting cases ready, sir. And I want to applaud them for that, sir. In fact, sir, I was surprised. I was indeed surprised and shocked that you represent, or you're being asked to represent a guy, say, in November. And then by January, and you're going to Master's Court, you're served with a file, and the case is ready, sir. So I want to make that point, sir, that we are not establishing a gun court for it to sit down there and don't have any production, sir. The cases are ready, sir. And this speaks, sir, to the fact, sir, that a gun court, initially the gun court, sir, in Jamaica was set up, sir, to ensure, sir, that there are speedy trials now. And that is basically the remit of the gun court. And similar to what we will have in Barbados, that we're trying to establish, sir, that we are establishing now, sir, to have speedy trials. And there's no way, sir, and I will say it again, I repeat it, sir, there's no way that a person who's charged with simple possession of a firearm, or simple possession, sir, of 2 or 3 or 4 or 5 rounds of ammunition, sir, should have, sir, particularly if he's on bail, should be walking around the country, sir, without his matter being heard, sir, within 3 or 4 months of him being served, or she being served with disclosures. And I say that, sir, because gun possession, sir, only involves, sir, police witnesses. It's a police case, sir. And that is why, sir, the move was made to fast-track the cases from January up to until this month to have the case ready, sir. Speedy trials, sir, impact, sir, on the reduction in crime, sir. Speedy trials, sir, ensures, sir, that dangerous offenders are off the street, sir. Speedy trials also, sir, respect, sir, the fundamental right, sir, of any citizen, sir, to have their case heard, sir, within a reasonable time, sir. Speedy trials, sir, ensure, sir, that there are undue delays too, sir. As you know, sir, delay is the nail of justice, sir. Delay is the nail of justice, sir. And so, this gun court, sir, I say gun court, sir, but it's really a division of the High Court. But I think we would term it as a gun court, sir. You know, sir, that even, sir, once we have these trials ready and we have a speedy trial in the gun court, sir. And we ensure, sir, that the sentencing, sir, move as fast as possible too, sir. Because we know, sir, that the starting point, depending on the factors, sir, depending on the first-time offender, sir, that the court within their discretion grant fines. And the court also within their discretion too, sir, can say, but he's a first-time offender, I can lock you up too, sir. It's a fact. That is a fact, sir. But whatever sentence, sir, is handed down as a result of the speedy trial, sir, will act as a deterrent for those persons who have the guns hide, somebody got them in the house, or they want to make an attempt to acquire an illegal firearms. But some people might ask, why you want to move these gun cases through the system so fast? What's the hurry? The hurry, sir, is because of the problem, sir, that exists. The problem, sir, of how these gun crimes are impacting on families. And that a first-time offender, sir, with a firearm, charged with possession of a firearm. In fact, I heard a trial judge even said that the days, sir, of a fine for possession of a firearm, that then days will soon be over. In fact, the legislation was intended, sir, to have a custodial sentence for possession of a simple firearm. But you cannot fetter the discretion of a trial judge, sir. A trial judge shall have the discretion to give whatever sentence he wants to give, sir. But I think that signal, sir, that is a warning, sir. And it should act as a deterrent, sir. That if, sir, that a learned trial judge can say that the days of gun fines are over, that should, sir, should be a signal, sir. But we must ask ourselves too, sir, whether these gun fines are being paid. Whether they are being monitored too, sir. And whether, sir, there's a supervision, sir, of these sentences involving fines for guns. And whether, sir, we have a proper mechanism in place to ensure, sir, that these fines are paid, so that these fines could go into the treasury, sir, and do some work and help, sir, with the criminal justice system in some small way or not, sir. But, sir, I have the statistics, sir, not the up-to-date ones, sir. But I know, sir, I see the member for St. Michael East is smiling, sir, when they talk about whether the fines are paid, sir. I know, sir, that I won't say that, sir, but I know sometimes, sir, the member for St. Michael East might be called upon. There might be a youngster who is gone in the car, sir, and innocently, sir, but sometimes, sir, you get charged. Evidence is kind of strong. And there might be an offer of a fine. And the reason, sir, that any reasonable man might be moved to assist that youngster is because the Penal System Reform Act, sir, don't provide for none of those orders under the Penal System Reform don't apply to firearm offenses. And that's something that we might have to look at, sir. Rather than further amendments to the Penal System Reform Act, that we place some of those orders on young offenders, sir. Young offenders. Young offenders. I want to make that point clear because, they got a calypso out there about the too soft on crime. I mentioned my name and the Attorney General name. A good melody, sir. I like it. A good melody, sir. I probably would have done a better job, sir, if you'd come to me to get some arrangements done. I would have done a better job, sir. Yes, sir. I would have done a better job, sir. But you still have, sir, to ensure, sir, that there's a rehabilitative part of sentencing too, sir. And that it is not a lick and lock up mentality, that some people deserve a second chance too. But in this environment, sir, we still have to walk carefully because of the age group, sir. The age group that are being charged, sir, as a first-time offender, sir. A possession of a firearm, murder of a firearm, endangering life of a firearm, sir, that we still have to walk carefully, sir, because of the serious nature of the offenses, sir. We have to walk carefully. I mean, not be a balance in it, sir. We have to balance it, sir. But the public safety will be prejudiced, sir. With the criminal justice system, we compromise. All of those things we have to look at, sir. But I have a view, sir, of firearm offenses, sir, and I have a view that they should not take no longer than 4 months to go before a court, whether the person want to plead guilty or whether they want a trial, sir. You know why, sir? Firearm offenses predominantly, sir, involve police witnesses, sir. So there's no question about unavailability of witnesses. There's no question about intimidation of witnesses, nothing, sir. There's no question about that, sir. The question, sir, is how do we get these statements ready? The question, sir, one, as you know, sir, you practice, you spend most of your time up there, sir, in the court, sir. Magistrates Court, High Court, Court of Appeal, CCJ, sir. One, sir, you need the statement of the investigating officer, sir. The person who go in the house with the warrant, find the gun, and charge him, sir. And then take him to the station and interview him, sir. That's one witness, sir. The second statement, sir, will be the backup officer, sir. We call the backup officer the person who was present. That's two statements, sir. We then need, sir, the ballistic expert, sir, who will then determine what type of gun and whatever, if it's in working order and all that. And then we need the record keeper that will come and say that this person is not on the books as a license holder of a gun. And then, sir, in some cases, you need the photographer. But that could come later too, sir. So there's only four statements. There are 4 statements, sir. I would understand, sir, that the ballistic experts in the police force, sir, that they might be overburdened, sir. But what the consultant, sir, is also suggesting to us, sir, is that we look, sir, for additional experts, ballistic experts, sir, in firearm cases, so that the existing experts will not be bogged down or overloaded, sir, or overworked. So you have now additional, sir, ballistic experts that can now move the cases faster and move these cases in a more quick manner so that justice will not be denied or justice will not be delayed, sir. And that, sir, it is my view, sir, and that, I believe, sir, it is the approach, sir, the Honourable Prime Minister, sir, in relation to having gun cases ready, sir. There's no need, sir, because it works both ways, sir. Case readiness go hand in hand, sir, with the presumption of innocence, sir. Innocence, sir. Particularly if a man is on remand with no bail for a year, sir, or 2 years. The case, you got to get the case ready. And there have to be a reason why, sir, that you charge him. And the reason that you charge him, because you believe that you have reasonable evidence to bring him to the court. So there's got to be evidence, so bring forward the evidence, sir. And secondly, sir, a man might want to throw in the towel, as you would say, sir. Throw in the towel, plead guilty. So you have to get the cases ready. So there's no way, sir, and moving forward now, sir, that the remit, sir, of this gun court, sir, is to have speedy trials, sir. And one might ask, sir, what is the staffing, sir? What is the staffing of this gun court, sir? Pray for your indulgence, sir. What is the staffing, sir, of this gun court? This court, sir, will be staffed by 2 judges of the High Court, sir. 2 legal assistants, sir. 4 marshals, sir. 2 probation officers, sir. 2 principal state counsel, that's prosecutors. 2 senior state counsels, sir, and 2 secretaries. We hope, sir, that we will have, sir, experienced prosecutors and some persons from the, by the way, from the private bar or whatnot, sir, who have an interest in prosecution, but it would involve training. It would involve training. You have to train them well, sir, because they don't want to go in court, sir, untrained and confront a lawyer by the name of the senior counsel, sir, or Angela Mitchell Gittins, sir, or Andrew Pilgrim, sir. Both senior counsel, sir. We have to train them, sir. We have to train them. Sir, I want to say, sir, that the stakeholders, sir, and when I say stakeholders, sir, I'm saying, sir, that we would have consulted with the important stakeholders in terms of establishing these 2 courts, sir. One of the concerns, sir, of the stakeholders, sir, as I mentioned before, is the timely disclosure of statements to have these matters ready for trial, sir. And that the issue, sir, of resolving, sir, the delays in the disclosure and the production of statements, sir. I can say to you, sir, that the DPP department, that they support the introduction of these 2 courts, sir. Because of the existing problems, sir, in the criminal justice system in relation to firearm cases, sir. One, sir, they noted that there's a high rate, sir, of acquittal at the High Court in firearm cases. You would have experienced that, sir. You probably got 90%, sir, out of 100, sir, in relation to your matters, sir. I probably be at a lower end, sir, of about 50. Sir, they mentioned the backlog of firearm cases, sir. I have the statistics here, so I won't go through them, sir. And, sir, there's the growing number of potential jurors from the exemption of jury trials, sir. I notice it, sir. I notice it, sir. I notice, sir, that you will get calls when it was practicing. I do not want to do jury trial. I am concerned. That is why the option is in here, sir. To have a trial without a jury, which is a judge alone trial, and a trial with a jury, sir. The issue, sir, of juror or witness intimidation too, sir. But that is why, sir, in Jamaica, sir, they had, sir, right in their legislation, no option for jury trial, judge alone trial, sir. They also, sir, opted to no publication, sir, of the witness name, no publication, sir, of the accused, no publication, sir, of those involved, sir, in the trial in the gun court of their names, sir. We, sir, in Barbados, sir, have passed the Criminal Proceedings Act, sir. And this, sir, is a protective mechanism for witnesses are persons who want to give evidence but are intimidated. They believe, sir, that it will cause harm to their family or whatever. But this is an important piece of legislation, sir. It is a beautiful piece of legislation, sir. And the reason I say that, sir, in this legislation, sir, it speaks to assistance to a witness on the grounds of fear or distress about testifying, sir. In this bill, sir, in this legislation, it creates special measures of protection for witnesses who believe, sir, who out of fear or intimidation don't want to give evidence, sir. But we must not see it, sir, from the side of the prosecution of an offense, no. It is also available to the defense. Because if you have, sir, a witness that could assist your defense, sir, but frightened to give evidence, you could invoke these provisions too, sir. It is not one-sided, sir. And I just want to go through, sir, these special measures, sir, because witnesses in gun crimes, sir, might not want, or might feel intimidated in giving evidence, sir. And that special measures are there in the law to assist them, sir. And these special measures, sir, in section 13 of the law, states, sir, the special measures that a party to proceedings may apply for include evidence to live link, sir, giving evidence in private, video recorded evidence, sir, video recorded cross-examination or re-examination, sir. So if the person, sir, do not want to be cross-examined or give evidence in front of the accused, sir, we could adopt these measures and you go before somewhere private but protected, sir, but still within the court, sir. Still part of the court proceedings. But, sir, this gives you the ability to give that evidence, particularly if it's a witness, sir. Particularly if it's an important witness to the matter at hand, sir. Sir, the important too, sir, players in firearm offenses, sir, and indeed, sir, even getting them off the street, sir, the police, sir. The police. And that is why, sir, we're seeing increased patrols and joint operations, sir, by the police service and the BDF, sir. That is why, sir, we are seeing increased surveillance, sir, an increase in the use, sir, very shortly, in the use of technology, sir, particularly, sir, in relation, sir, to the importation or, well, the attempted importation of firearms, sir. I always say, sir, Barbados don't manufacture firearms, sir. Don't manufacture firearms. So the people ask how they get in here, sir. How they get in here, sir. But I don't want, sir, to release, sir, because of national security reasons, sir. Of the improvements, sir, or the changes that we made, sir, to plug those holes, sir, within the system, sir. I mentioned, sir, the contracting, sir, of future ballistic experts from overseas, sir. That's important too, sir. I mentioned that before, sir. But all in all, sir, this bill and the amendment to this bill is historic, sir. Extremely historic, sir. It's historic from my point of view, sir, that we have now we will have two specialized courts, sir, dealing, sir, with firearm offenses, sir. I say that, sir, too, given, sir, the bill, that the referral to this court, sir, means, sir, that the court will also deal with bail applications, sir, for firearm possession and firearm-related matters, sir. And hopefully, sir, that too will speed up the process too, sir, instead of having to wait, sir, on whether your case will be assigned to which judge or whatnot. But you know, sir, with certainty, sir, and there's certainty in the law, sir, you know with certainty that your matter can go before one of these two courts. You know for a fact, sir. So there's certainty, sir, that we are bringing about, sir, in terms of the criminal justice system, sir. Sir, the firearm court signals an indication and send a message, sir, to the public of Barbados that not only, sir, that we are stopping at the anti-gangs bill, sir, but we are bringing measures, sir, to confront, sir, this challenging issue, sir, of crime, sir. It comes behind, sir, a number, sir, of crime-related solutions, sir, that we've walked time and time and time and time again, sir. We have now increased, sir, prosecutors were increased before, no? So we now added 2 more prosecutors, sir. We increased the criminal judges before, sir. And we now added 2 more judges, sir, 2 criminal judges, sir. We've passed, sir, a string of legislation, sir, that will impact, sir, on the criminal justice system, sir. I didn't go through the clauses, sir, but I know that the Learned Attorney General, sir, will flesh out the sections. But I want to give a general overview, sir, of the establishment of these 2 courts, sir. And I want to say, sir, to the public, one, sir, is about backlog, and the other one, sir, is about current cases, sir. And the current cases are ready. I will repeat it again, the current cases are ready. So those persons who were charged in January, as soon as this court, sir, and I hope, sir, that it go up to the Senate as soon as possible, sir. And I hope, sir, that we have the resources. In fact, the resources are ready. The posts, all posts in these 2 courts, they have been approved, sir. They have been approved. There's a matter, sir, going out to the public and getting the best of the prosecutors and getting the best of the brains, sir, judicial brains, sir, to man this court, sir. The issue, sir, of having, someone might say, sir, that they're only limited defense lawyers in Barbados, so how are you going to get this court staff? Those are the issues, though. You've got to preempt those issues. Those are the issues that will come, sir. But I would ask myself, sir, there are so many young attorneys, sir, that get called to the bar every year, sir. When they got called to the bar, and you got called to the bar, sir, we were pulled in at the deep end. Your senior will come to you and give you a case and say you have to run with it and do the trial. You have to learn some ways, sir. Either, sir, we develop what we call a public defender's system, where we have a set of lawyers who will be out there, sir, working before charge and working after charge, that means at the trial, that will be able now to come and start these trials, because they will have all the information, they will have all the instructions, and they will be ready to do the trial, sir. So I'm not against, sir, a public defender system, sir. I'm not against that. But in these, sir, there will be these cases, sir, will be treated with priority, sir, these gun cases, sir, because it's important to send a signal, sir, to the public, sir. And, sir, with that, sir, I move that this resolution be read a second time, sir. The bill, sir, my apologies, sir.
Honourable St. Joseph.
Mr. Speaker, I rise to lend my support to this bill, Supreme Court Bill 6. And it will set, sir,
Your mic is on, Honourable Member.
my apologies. Mr. Speaker, I rise to lend my support to this Supreme Court Amendment Bill 2026. At the outset, I want to commend the Minister of Legal Affairs and Criminal Justice, as well as the Attorney General, for bringing this bill before this Honourable House. I also wish to commend all those involved in bringing this bill today. Now, this bill seeks to increase the number of judges available to serve in the High Court. It also seeks to establish a dedicated firearms division of the High Court and to provide a legal framework for the hearing and determination of gun-related offences. And Mr. Speaker, this debate extends far beyond the provisions of this legislation. This debate concerns the broader administration of justice and the effectiveness of our institutions to respond to the evolving needs of our system. This bill is about preserving public safety, and it is about protecting law-abiding Barbadians. And as members of Parliament, Mr. Speaker, we have a responsibility to ensure that the institutions that are charged with providing justice and protecting our citizens are fit for purpose. And we have to ensure that the legislation that comes before us helps to equip our arms of justice to meet these challenges. And today, sir, gun violence and gun-related offenses are one of the challenges that plague our society. The question before us, therefore, Mr. Speaker, is not whether firearm crime and gun-related offenses is a problem in our society, because the statistics already show that 23 out of the 27 homicides this year are gun-related. And gun crimes don't respect where you go to school, where you're from, which district you're from. They impact every single person. And I approach this debate today, Mr. Speaker, from a unique perspective. I am not a career attorney. I'm not a lifelong politician. But I am someone who has been impacted by gun-related crime. It was only maybe 10 years ago when I was held at gunpoint within the curtilage of my home. And it is a unique perspective because being confronted with a firearm and you don't know what will happen next, it causes you to think and reflect in a very short space of time. And Mr. Speaker, while I was fortunate enough to survive that ordeal, there are many persons who do not leave those circumstances unscathed. And this is why we see our statistics continue to rise in terms of gun-related violence. Sir, one of the key provisions of this bill is the increase of the number of judges available to sit in the High Court. And I consider this to be both a practical and a necessary measure. We have all heard the saying that justice delayed is justice denied. And when cases remain unresolved for years, Mr. Speaker, victims suffer. Families suffer. There's no closure. The public loses confidence in our systems. And so, increasing judicial capacity, Mr. Speaker, will assist in reducing the backlog of cases. And certainly it will help to provide access to justice for many Barbadians. And it is for that reason, Mr. Speaker, that I support this amendment. And I also support the second major component of this bill, which is to establish the Firearms Division of the High Court. Specialization, sir, has become a feature of our modern justice systems. And even at this point, I want to speak to the work that was done by my predecessor, former Attorney General Dale Marshall, in helping to modernize our criminal justice system. We saw the establishment of the family court because we recognize that family-related issues are complex and they require special attention. It therefore follows, Mr. Speaker, that firearm-related offenses, which have also become increasingly serious and complex, should also benefit from a dedicated judicial division. The third aspect, sir, is the legal framework, which promotes consistency and certainty in the administration of justice. And this will ensure that firearm-related offenses receives the level of attention, that it receives the priority and the procedural clarity that the seriousness of these offenses demands. I also acknowledge, Mr. Speaker, that legislation, where appropriate, should prescribe specific statutory timeframes for the performance of key functions and responsibilities. Such provisions, sir, can provide certainty, transparency, and accountability to both the public and the institutions charged with administrating the Act. And we recognize that where operational realities require flexibility, that the subsidiary legislation or the regulations can deal with this. What matters most, sir, is that there's no ambiguity regarding the period for which these decisions must be made, applications processed, and matters determined. So we would want to know, sir, the public would want to know and understand that cases can move through the Firearms Division in a swift manner. The whole point of establishing this division, sir, is so that we can address the backlog and bring justice and provide greater access to justice for regular Barbadians. And Mr. Speaker, while I wholeheartedly support the legislation, I believe that there are just three broader perspectives that merit consideration as we move towards implementation. First, I believe that this legislation should be viewed as part of a wider strategy to improve the administration of justice. It is true that the establishment of this Firearms Division, or as my colleague stated, this gun court, will provide significant institutional reform. As I said, it recognizes that firearm and gun-related cases are complex. And if we don't seek to evolve our system to respond to the complex nature of these gun-related offenses, the public will not have confidence in our justice system. But the true measure of this legislation, Mr. Speaker, isn't simply about the creation of the new division, but the extent to which matters can be resolved in a timely manner. So as a parliament, Mr. Speaker, we should therefore remain attentive to the outcomes, to the true results after we implement this gun court. Courts do not operate in isolation, Mr. Speaker. Their effectiveness is influenced by the quality of the investigations, the availability of forensic evidence, the preparedness of prosecutors, and the willingness of witnesses to participate in the process. This legislation, Mr. Speaker, reflects the need for modernization of our criminal justice system and building institutional capacity. And by modernization, I speak to the use of technology, sir. Having read the bill, I welcome the provisions which allow for hearings to be conducted by video conference and other electronic means. And these measures, Mr. Speaker, reflect a recognition that the justice system must continue to evolve to meet contemporary demands. And as we move forward, and as we bring other bills to this honorable chamber, we must recognize that investing in technology, administrative support, judicial resources, and modern case management practices should be a feature of all that we do if we are to continue modernizing and improving our criminal justice system. So these observations, Mr. Speaker, are not criticisms of the bill. They're rather reflections on how we can maximize and benefit more from what it is that we're doing in this honorable chamber. The establishment of this gun court, sir, sends a clear message to Barbados that this Parliament is serious about addressing this scourge that is plaguing our society today. And we see, as I mentioned, the statistics, our gun-related homicides have been rising steadily over the last 3 years. And based on the trajectory thus far for this year, it is not looking as though we're going to retreat, but as our president says, no retreat, no surrender, sir. And I believe that this legislation is a direct response to us not giving up on our young people and surrendering to the scourge of gun-related violence. But, Mr. Speaker, as we discuss firearm-related crime, it is also imperative that we reflect on the root cause of what is causing this crime. No court can address what is happening in the homes of Barbadians. No judge can substitute for a parent. And no sentence can replace the opportunities that our young people have to develop. The long-term solution to crime lies within our communities, Mr. Speaker. It lies in education. It lies in sports. It lies in youth development. It lies in job creation. It lies in mentorship. It lies in creating opportunities and circumstances where young people can see a future for themselves beyond crime and violence. And as someone who has spent years working with young people through sport, through community development, through cultural projects, I can say confidently that most young people just want opportunities. When those opportunities, Mr. Speaker, are absent, this is when we see young people turning to crime. When those opportunities are absent, Mr. Speaker, we then see the negative influences filling those voids which exist. Therefore, while I support and strongly and wholeheartedly support this bill, Mr. Speaker, I also believe that we must continue investing in preventative measures because prevention remains better than cure. And while, Mr. Speaker, I am pleased that the legislation preserves safeguards relating to children and young persons through the continued application of the relevant child protection legislation. We must strengthen our response to crime. We must never lose sight of fairness, proportionality, and rehabilitation where necessary. In bringing this legislation, Mr. Speaker, the people of Barbados expect action. The people expect that we provide solutions, real solutions for real people. And it is my hope that as we seek to address the backlog of cases, Mr. Speaker, as we seek to increase our judicial capacity, Mr. Speaker, as we seek to implement technology so that the access to justice becomes more prevalent, I want to remind Barbadians that, above all, that this Parliament and this Honourable Chamber foremostly remains committed to protecting law-abiding citizens. And in doing so, Mr. Speaker, all the legislation that we bring to this Honourable Chamber, sir, must be supported by opportunities for our young people, as I said, so that they don't get bored, and so that as much as we have a gun court, that we don't leave room for the negative influences to infiltrate them and to distract them from becoming the good law-abiding citizens that they are called to be. So with those words, Mr. Speaker, I want to again reiterate that I fully support this legislation, and I look forward to its swift implementation as we continue to wrestle the scourge of gun-related violence to the ground. I am obliged.
Honourable Christchurch East.
Mr. Speaker, sir, I wish to start by commending the Honourable Member for the City for taking us further into our suite of crime prevention and crime addressing measures. Now, sir, everybody knows that we recently debated the criminal gangs legislation. I mean, it's been a hot topic in Barbados for the last couple of weeks, and the persons who have come to me and asked me about it, I am quite amazed, sir. There's some people that you don't think are actually paying attention to some of the things that we do, who have paid attention in particular to what has happened. It's a confluence, sir, of circumstance, national circumstance, is a confluence of community concerns, and it's also, sir, people reading the room. Bajans, sir, love to be devil's advocates. And very seldom are we all in ad idem on a particular point. As much as we love Barbados, we have to concede, sir, that there are those who do not love Barbados as much as we do, or do not love the idea of what Barbados represents as much as we do. Maybe because of the position I'm in, sir, there are certain things that I want to say, certain things I want to do, I would not do it. Because in my position, my words aren't my own. Anything I say reflects on my party. Anything I say reflects on my role as Attorney General. The things I said I reflect on my mother, my father, my wife, my friends. So I've gotten into the habit of tasting my words. I've also gotten into the habit, sir, of reading the room. If I'm in a situation, sir, or I'm out somewhere and I see tempers escalating on something, I'm going to leave. I'm not going to stick around to see what happens next. I'm not going to stick around, sir, to catch it on this and be the first to post it. Right? Sometimes I'm amazed, sir, at the pictures that people and the videos that people manage to get because they put themselves in the direct line of harm in order to secure the likes and the first postings on social media. I believe, sir, more of us should actually read the room. This legislation, sir, is an example of the government reading the room. It's an example of the member for the city reading the room. Everywhere we go, or everywhere I go, I get, well, if somebody's against the government, they say, what you all doing? Barbados running away. If there are people in favor of the government, they say, look, we know you're doing the best you can, but you got to get this under control. And while, sir, I cannot actually control the hand of a man who gets up and gets on a motorcycle with a gun and goes about looking for somebody in a neighborhood, while I cannot control him, as part of this government, so I can control what happens next. We may not be able to directly control the actions of persons, but it's our duty as a government to put the protocols, procedures, the infrastructure, all of the necessary things in place to secure and safeguard Barbados and Barbadians. That means tightening the police force where it is necessary. That means resourcing the police force. Sorry, I said force. The police service where it's necessary. That means having no shame in bringing the BDF in for joint patrols with the police. That means having no shame at all, sir, in having the BDF undergo courses, because we accept and recognize their enhanced position in crime fighting and security concerns in Barbados, so that we ensure that the members of the BDF who go out with police also have training in police protocols. They know what is or is not acceptable. They know how far they can or cannot go. It is for us to do all these things. But then, sir, when the person is caught, then what? When the person has been picked up by the police, then what? Last week we dealt with the anti-gang legislation, so that persons who commit crimes in gang-related circumstances know what they're facing. They know it is not business as usual. They know that the heavy stick has come out, and the sentences are going to be hard, they're going to be heavy, and they're going to be uncompromising. They know that. But until such time as you get to the point of sentence, then what? There's still other things that come into play. Right now, sir, some matters, there's concern as to exactly where do firearms sit in the priorities of government and in the priorities of the judicial structure. We know that at one point in time, there are certain aspects of firearm crimes that resided in the bosom of the magistrate. Pretty much all firearm crimes now go before the High Court. But go before the High Court to which judge? Go before which version of the High Court? Go in priority to what? For years, sir, based on the evolution of priorities, the court established divisions. When I came into practice, sir, some 30 years ago, we had the civil court and we had the criminal court. That's it. We had two divisions. Certain prominent attorneys, sir, if I may call their name only because it's in a good way, and people know who they are and what they did in this respect. Certain prominent attorneys, sir, Margot Green, QC, Beverly Waldron, QC, Jackie Cornelius, I think there's no Jackie Cornelius Thorne, many of whom went onto the bench. They were hell-bent on getting the recognition of a family division of the High Court. And the family division of the High Court was established. It had its own rules, it had dedicated resources. The judges who sat in the family division were given specialized training, and they heard only family cases. And that sort of helped to make sure that cases went to where they could get the priority with persons who understood the nuance of that particular area of law. Sir, eventually, because of need, Barbados has to look at its ease of doing business. We have, I think, the major contributor to our economy outside of tourism is taxes from the international business sector. But to be able to entice businesses to domicile in Barbados and invest in our economy and our structure, we have to assure them that if issues arise, as they will, that they can be dealt with swiftly, expeditiously, fairly, by competent persons. So we created the commercial division of the High Court. All of these divisions, sir, we call it the commercial court, we call it the family court, we call it the civil court, but there are divisions of the umbrella of the Supreme Court of Judicature. It is now time, sir, to create another one. Because of what we're facing in Barbados, because of the priority being given by this government to halting the escalating firearm-related offenses, because of the need, sir, to plug certain loopholes that exist in our system that allow people to benefit from delays, inordinate delays, it was deemed expedient and well advised at this time to create a new division of the High Court, and that division is the gun court. Sorry, the firearm division of the High Court, which for the purpose of this, I'm going to slip and call it periodically the gun court, but you know, sir, we know what we're referring to. We follow a number of countries in doing this. At one point in time, nobody wanted to do it because to create a gun court was to admit that there was a need for a gun court. Nobody wanted to admit that we're at the point, or that our country's at the point where guns are such a concern that it's necessary to actually dedicate resources into a specified, specialized court to deal with it. So that horse is already bolted. Those political concerns, sir, have been overcome by the political concerns of us having to answer to the electorate. What are we doing? We follow behind, sir, Jamaica for certain, I think Trinidad. We follow behind a number of other countries in the rest of the world who have said that this needs a dedicated structure in order to properly deal with it and to show how serious we are. Now, so if I go a little bit further to talk about the loopholes, we all know that a person is entitled to bail. It's the right of a citizen of Barbados to be free. Freedom is one of those constitutional rights. You should only be deprived of your freedom by reasonable excuse. And you have a right to speedy trial. If for some reason you are arrested and charged, then you have a constitutional right to have your case heard within the shortest time frame as reasonably possible. It is based on those two constitutional rights, sir, that persons have been able to get bail for firearm offenses. We had tried the route under a previous manifestation, the Bail Act, to deny bail for firearm offenses. But realistically, sir, when you can't get a man on for trial 2 years, 3 years after he's been charged, then as abhorrent as it is to the citizenry of Barbados, especially when the charge is murder or something equally heinous, the fact is the accused man has rights as well. A man is innocent until proven guilty. And if we say he should not get bail because the circumstances of this crime were so offensive, and that the evidence against him is so strong, then what is the reason for not bringing him on to trial? If the circumstances are so offensive and the evidence is so strong, then there is no good reason the trial should not happen in a short space of time. When people go before the court saying, look, I sat down at Dodge 2 years, none happened in my trial, I didn't get disclosure yet. It is hard for a court that knows what the constitutional rights are to say to a man, we can keep holding you indefinitely. The prosecution can't give a time to start the case. We can keep holding you indefinitely. That is why, sir, this government has taken the decision that firearm cases and murder cases are to be done within a specified period of time, the shortest time possible. I think they're supposed for simple cases, sir, within 6 months, right? And for longer cases, 9 months, I believe. But short, defined timelines. Why does this make another difference? When we think of a firearm-related offense, sir, automatically, all of us think that somebody has been shot. When you think of firearm-related offense, your mind goes to murder. Now, interestingly, the talk in Barbados is back on a death sentence. Let's call it what it is. It is not, people don't want to address it politically. But, sir, since January, two persons came to me and said, Abrams, if the government ever decide to start hanging back people, I want to apply for the job. Sir, no, two came to me. So I had to smile at one because he looked so entirely eager and willing to do it. And he said he would do it for free. That if it got to that, sir, I don't want him. He won't be listening because let him know, as of last Saturday, you're hearing it officially from me. If that position ever becomes available, I am not recommending you for it. You're too happy. But the fact is, it's a conversation that's coming up. And it's a conversation that's coming up mirroring the frustrations of people who are saying, well, unless we act as drastically as the criminals are acting, we're not going to stop them. We've done what we had to do with the anti-gang legislation. We're doing what we have to do, sir, with respect to this gun court legislation. There's some other legislation coming down the pipeline, sir, that is going to seal off everything. Every hole that we've identified in legislation, every loophole, we intend to plug it. And after we've enacted the legislation, sir, if anybody finds another loophole, we can come back and plug that too. We are taking this very, very seriously. Now, everybody, sir, knows about the Pratt and Morgan case. I was having a discussion with a judge who said to me that people in Barbados need to remember that the death penalty is not off of our books. The death penalty is still an option for sentencing for murder and treason. I'm going to take this point now, sir, just to explain something to Barbados and Barbadians. While it is there in the Pratt and Morgan case, which is a Privy Council case, the court said that executing a prisoner after they have spent more than 5 years on death row constitutes inhuman and degrading punishment. And this 5-year timeline, sir, has been recognized in Barbados. No, we are not subject to the Privy Council, we're under the CCJ. But the Privy Council being one of the highest decision-making bodies in Caribbean jurisprudence, we have to take note of what was said there, sir. So although we are not bound by decisions of the Privy Council, the fact is you take judicial note. You're advised as to them. They're persuasive as opposed to binding. Now, the Pratt and Morgan case set out some rules. 5 years. 5 years after the initial sentencing. If you try to execute somebody after 5 years, it's likely to be found unconstitutional. Now, bear in mind, sir, that the accused person has the right to exhaust all appeals. This is the most final sentence that can be done, can be executed. Death. You can't come back from that. So that person has the right to exhaust all of his appeals. If, sir, a man does not appeal his death sentence, some lawyer steps forward and files an appeal on his behalf. Somebody, there has to be something mentally wrong with you if you get a death sentence and you say, I'm not appealing that. You have a right to appeal that death sentence. No matter how strong the evidence against you, no matter how firm the evidence against you, no matter how many witnesses, no matter how conclusive, if you appeal that as of right, you will get an appeal. If you lose your appeal at first instance, at the level of your Court of Appeal, sometimes you have to seek leave to appeal even higher than that. You will, as of right, get the appeal to your highest court, which in some parts of the Caribbean is the Privy Council, for us is the CCJ. After you've exhausted your domestic courts, and for us, after you've gone to the CCJ, let's say the CCJ affirms the decision, you have the right to apply to the International Human Rights Court. And those people, you know, sir, take forever. They do. I don't want to tread on my parliamentary privilege, sir, but it is known that they have no intention of sanctioning death penalty. So they will take forever. We have to change the law in Barbados to allow for the fact that if you overrun the 5 years, effectively due no fault to the Crown, then you can still carry out the sentence. But sir, the CCJ in a case said, and this is nutshelling it down, because the legal and appellate machinery in Barbados routinely takes longer than 5 years to exhaust all legal remedies. This is Boyce and Joseph, right? Because the legal and appellate machinery in Barbados routinely takes longer than 5 years to exhaust all legal remedies, and inter-American systems petition capital punishment cannot lawfully be executed, and this contributes to the country's de facto abolitionist status. Effectively, because we can't get the whole process done in 5 years, although it's on the books, it can't be carried out. I go again, it remains on the books. What does that have to do with this? We are now focusing our attention and our resources on having these cases done speedily to create options for the court. The court must have options, but for the court to have its options and timelines have to actually make sense. In a number of the pieces of legislation, sir, that are coming before you, you realize that there's been a shift towards the seriousness, punishing the seriousness of the offense and creating options in the courts. Now, sir, I'm going to take you through a bit of the details of this particular piece of legislation. Section 27B1, Section right, sir. There's to be established a firearms division of the High Court to be known as the Firearms Court. The Firearms Court shall have jurisdiction in all firearm-related offenses, all, every single one. The question is, when we do these two courts, if for some reason they have nothing, if they perform so well that they clear up all their backlog, then we're wasting resources. I've heard that being said, that we're putting resources into courts where we might not have need for the courts. Sir, that's addressed here, and it says the firearm court shall have jurisdiction here and determine the following: all firearm-related offenses and any other related offenses which the Chief Justice may assign to that court. So it is not just, sir, the strict firearm offenses. If something is relatable, if something is ancillary to, if something is peripheral to, then it can be assigned there, sir. Now, whether something falls to be considered a firearm offense or firearm-related matter is within the jurisdiction of the same firearms court, and it should be decided by that firearms court. The point about this being a division of the High Court is reinforced, sir, under 27C3. Without prejudice to generality of this section, there shall be vested in the Firearms Division of the High Court all the like powers and authorities as are vested in the Supreme Court and a judge thereof. And for the purpose of this Act, a Supreme Court judge exercising jurisdiction in that division in relation to any offense shall have all the powers of a judge. So the bottom line, sir, is that it is just a jurisdiction of the High Court, but a specialized jurisdiction of the High Court. And just to clear up when you get anomalies in previous legislation where it might refer to jurisdiction in magistrate's court or anything like that, sir, in any proceedings under related enactment, this is 27C4, a reference to the High Court, magistrate's court, court of summary jurisdiction, or court shall, in relation to a firearm-related matter, be read and construed as a reference to the firearms court. So don't mind that something is not consequentially amended. If you see something dealing with firearms, no matter what court is assigned to or what jurisdiction appears in legislation, it is to be read as applying to the firearms court. Sir, the citizen of the firearm court, 27F1, citizens of the firearms court should be held at such location and at such time as the Chief Justice, in consultation with the judge of the firearms court, may appoint in accordance with this Act. Now, I was going to deal with that one by itself. I'm going to deal with that in conjunction with the one that comes after it. Notwithstanding subsection 1, the one just read, the firearms court may, when required and appropriate, sit at any time and may conduct hearings by telephone, video conference, or other appropriate electronic means. Now, matters were raised in other jurisdictions in relation to the seriousness of and the transport of prisoners. That because of gangs and because of the nature of firearm offenses, that even the movement of some persons might cause a security concern. So under this amendment, under that section, the Chief Justice can, in consultation with the judge, determine that a matter can be heard at the prison. If for some reason you need to take evidence or a specific part of it, then the court moves itself down to the prison or the BDF or some other secure facility to enable this to happen. Or if you, sir, don't wish witnesses, the honourable member for the city, in debating the gang legislation, had indicated that there was a time when a witness gave the evidence and came out of court, and all the family of the accused man were there, and they made gestures indicating, we know where you live. So, sir, a witness can be heard remotely. So this allows for the Chief Justice and the judge managing the case to take cognizance of the realities of the case and act appropriately to secure the evidence and be the safety of everybody else involved in the matter, sir. Now, children feature very heavily in all of our legislation. In our gang legislation, the one concession that was made, sir, was in relation to a parent harboring a child, where if the parent or the person local parentis show that they were trying to reform the child, they get a slight consideration. We also protected the children in relation to the recruiting of children in the vicinity of a school or a place of worship. Sir, under Section 28G, notwithstanding anything to the contrary in this Act or any other enactment, the provisions of the Child Protection Act 2024 and the Child Justice Act 2024 or any relevant enactment shall apply in the case of a child. We, in those two pieces of legislation, dealt exactly how we deal with children in custody or children in conflict with the system, and the rights that are enshrined in those children-specific pieces of legislation shall have predominance over this piece of legislation. So we factor that a child still has to be treated as a child, and we have a framework for dealing with children who are in conflict with the law, and notwithstanding any provisions in here, the children will still be treated as children under the child justice legislation and still be protected as children under the child protection legislation. Sir, the honourable member for the city also pointed out that this allows flexibility for the cases to be heard with or without a jury. So for the purpose of this Act, a judge sitting with or without a jury shall constitute the High Court Division of the Firearms Court. The court is constituted by a judge sitting alone or a judge sitting with a jury. Sir, in some cases, when we try to select jurors come, depending on who the person is who is accused, people come with all the excuses in the world why they should not sit on that jury. I mean, the reality is they're frightened. That's the reality, they're frightened. You don't want to sit opposite Barbados' most wanted and hear the case trying the whole time not to make eye contact with the person. And then when you come back with a verdict of guilty, the person don't know whether it was you, whether it was not you, but it was one. So the fact is we have to embrace that a time is coming when judge-alone trials, especially for these type of offenses, are become more prominent. In Jamaica, I think the High Court, the gun court sits with a judge alone. But we have preserved the right of the individual to the jury, and to have a jury, a jury of his peers. But sir, we also have to be aware of the circumstances. Now, 28I4, without prejudice to the foregoing, the Chief Justice may by order regulate any other arrangements for reference to trial of cases in such division, and any such order may contain such consequential, supplementary, or ancillary provisions as appear to the Chief Justice to be necessary or expedient. So once we have settled this, sir, and the court has gone into operation, the Chief Justice effectively has the right to give practice directions. As the law is applied, as the cases are done, you're going to sometimes see things that make sense to change. It should not have to come back here to make minuscule changes that are really administrative or functional. So as the Chief Justice has the right to make practice directions in relation to civil matters, this enshrines here, it doesn't say practice direction, but effectively that's what it is. It gives the Chief Justice the right to make supplementary provisions or practice directions to direct the function of the court, sir. The The other thing, it also carries further in the same subsection. The firearms court may, if it's satisfied that requirements of justice render it expedient to do so, transfer any case brought before it to any other court having jurisdiction in the matter as may be appropriate, and the record shall be endorsed accordingly. Sir, if realistically there's a firearm involved, but there are many other things involved, a whole set of people that are charged in one thing, it may be expedient, sir, that the court thinks, rather than try this by itself, it would stand to be properly tried in conjunction with the rest of the cases. And the court, as it has the jurisdiction to determine where its jurisdiction lies, what constitutes a firearm-related matter, it also has the jurisdiction to where it thinks appropriate or where its requirements have been satisfied, where it say is expedient in the interest of justice to do so, transfer the case to somewhere where it can be properly heard with other cases and dealt with expeditiously. My good friend, the Honourable Member for St. Joseph, made the point. Barbados, we're doing this for you. At the end of the day, the purpose of this is to secure protection for Barbados and Barbadians. We want you to feel safe going about your business. We want you to feel safe in your homes. We want you to feel safe knowing that the person who was arrested and charged for shooting at your house ain't coming back out in 2 years because his case not starting for 10. We want you to feel safe that the cases are being done as quickly as possible. And why is it necessary as well to do cases as quickly as possible, sir? The longer you take with the case, the more unreliable witnesses become. The longer you take with the case, the key witness is going to die. The person may move over to Barbados and don't come back, and then come back for the trial. They're going to put that behind them. Witnesses' memories, sir, get shaky. The longer you wait, the easier it is for defense counsel, sir, to mess up the witness, to trick them. But you said it was a Tuesday at 3:30. You're now saying it was Wednesday at 4, and the whole case collapses because the person got an alibi for one day.
Honourable, that's not a trick, you know. That's a line of questioning. That can't be deemed a trick. It's posing a question.
Sir, in light of all the circumstances, sir, I will myself order that I be struck from the record. Let me not assign trickery to defense counsel, sir. Let us assign innovative, creative, and self-serving arguments and positions instead. But the point is, the longer you wait, is the harder it is to convict somebody. The easiest it is to get reliable evidence is very quickly after the fact, when the evidence is fresh in people's mind. That's why, sir, when a witnesses something, you try to get them in as fast as possible and put it all down as fast as possible. Your recollection a year from now is going to miss out certain details. I may forget that you had on that tie. And that tie may become an issue because somebody said you were wearing a t-shirt, and then we're not certain that you were there. Two different versions, times. So, sir, we are now trying to do what's right by Barbados. The length and the delays frustrate the victims. It frustrates the families. It undermines confidence in our judicial system. It undermines confidence in the rule of law. It undermines effectively our perception that all is well, that the government has it under control, that the police have it under control, that the courts have it under control. We have looked at all of the legislation, sir, relating to serious criminal offenses. And we're going through them one by one. Where they need updating, we'll update. Where they need amending, we will amend. Where they need scrapping, we will scrap. Where they need innovation, we will innovate. But it is a process, sir. It is a process. Legislation is never perfect. The good thing about going second sometimes, sir, is that you benefit from other people's mistakes. When people are first movers, you can see what didn't work. Sometimes they're correct. And we find ourselves now in a position of probably having the most comprehensive setup as it stands now. The initial concept was to actually have a gun court standing by itself. And the point was our Supreme Court Judicature Act was sufficient to absorb a gun court into the structure and give it the priority of the existing divisions of the High Court. So that we are saying guns are as serious as criminal law, civil law, family law, and nothing is more important than families, and commercial law. It is on the same footing. The two courts should have their own dedicated staff. They should have specially trained prosecutors. They should have the CAT transcribers. The courts are being set up to function effectively and efficiently. They will have dedicated judges who are fearless, who are decisive, and who actually understand the message that the government is trying to send as well. So, sir, it is a short amendment because, as I said, we're just simply amending an existing structure. But it was a critical amendment. It is one that says to Barbados, we have heard you. We live here with you. We are tired of it too. We will do everything we can to get this back under control and to give the judges all of the options that the law currently provides for them by removing the loopholes and removing the delays which prejudice the administration of justice in Barbados. So I wish to thank the Honourable Member for the City for bringing this piece of legislation here. I hope I've served in some way to explain it a little bit to people. And sir, I firmly and completely am in support of this legislation. I thank you, sir. Sir, I beg to move the suspension of the chamber for 10 minutes, sir, until 20 past 12.
The question is that this honorable chamber be suspended until 20 after 12. All those honorable members in favor, please say aye. Aye. Those against, please say no. Meeting the ayes have it. This honorable chamber stands suspended until 20 after 12. She was it. Huh? The sitting is resumed. Honourable Prime Minister.
Thank you very much, Mr. Speaker, sir. I rise to participate in this debate and do so conscious that on yet another occasion, this government is moving to increasing the number of judges in our court system, but particularly in the criminal division. The difference being that on this occasion, it is being narrowly focused on one type of offense. When we came to government 8 years ago, the criminal division of the High Court had 2 judges. 2 judges. They now have 8, and in spite of that 8 and that significant increase there, and concomitantly with the number of prosecutors, we have determined that it is still necessary to establish a dedicated gun court, because there is no greater scourge on this land than the prevalence and presence and use of guns. I have said on many occasions that Africa succumbed to a handful of people as a result of gunpowder. I say to us as a nation what I said on every occasion, but I recognize that when I said it before, it may not have had the same resonance as it may have now, even with our cultural practitioners, who may not quite have understood what I was saying a few years ago when I asked that we as a nation bind ourselves together, bond together, and take the issue of fighting guns, removing guns from our environment, as a whole of nation exercise, rather than the province of one or 2 sectors of this society. So I don't intend to speak very long, because my views are well known on this. And I have taken comfort in understanding that my appreciation of the criminal law, which predates my political existence, allows me to understand that justice, when delivered quickly, is the best form of crime prevention. Justice, when delivered quickly, is the best form of crime prevention. And that is what motivated the government, as you know, Mr. Speaker, in increasing the number of judges from 2 to 8. We inherited a backlog of over 10,000 cases. And this is not about blame now. This is just about setting the context. And then to add insult to injury for us, more than 2.5 years were lost during COVID because of the shutdown and then the inability to conduct jury trials with ease. And therefore, whatever progress we were making with the backlog was regrettably affected, and the situation became compounded. Now, the government, through the actions of the last Attorney General, introduced and started the process of the modernization of our criminal justice system with the introduction of a number of pieces of legislation. The one which, however, that is of greatest relevance to reducing the backlog was the one empowering the prosecution to do plea bargaining. I'm happy to report that from the information received by my office, from the Office of the Attorney General, prior to this Attorney General and since with the new Attorney General and with the Minister of Legal Affairs and Criminal Justice Reform, that these instruments provided for in the law are now starting to work, and we have every confidence that they will continue. It is my judgment that they will need a dedicated unit in the Office of the Director of Public Prosecutions to manage the plea bargaining, to reduce the number of cases that are the subject of backlog. And that will be another instrument that we will use in our arsenal to be able to ensure that we can have effective justice delivered for the benefit of the victim, but equally in accordance with the constitutional provisions for due process that are there in our fundamental rights section to protect the accused person. But this legislation that is before us, sir, this bill, is another way by which we will take those cases that have the greatest capacity to destabilize this nation beyond the victim, the nation, and to inspire a panic of fear in our people that should not be part of our landscape. I have said over and over, guns don't walk, guns don't talk. In fact, a gun without ammunition is useless too. And therefore, we have, as a society, to work assiduously in being able to deal with this scourge. Sir, we have had instances even recently, and I speak of the concern at the systemic level, that persons who go and operate at gun clubs, whether as part of the law enforcement or as individuals, will have to be assiduous in accounting for every piece of ammunition, such that ammunition is not sold in contravention of the laws of this land to persons who should not have it, and to persons who have no license to carry either firearm or ammunition. Sir, the law will be applied vigorously and swiftly on any matter to do with guns or ammunition in this country. I believe where others feel that the battle is lost, forgive me for feeling that as long as there's breath and as long as there's capacity to reason, that the battle is never lost. It may mean that we have to redouble our efforts in speaking to our people, and in particular our young people who may see a gun as a badge of honor. Left to me, you know that nobody would be allowed to carry guns. And I've said that's my personal position. But I accept that the society is not of the same view. But if it is not of the same view, sir, then it is imperative that the rules and regulations that facilitate those who carry it legally must be applied vigorously. I was the Attorney General, sir, who insisted on the introduction of psychological and psychometric testing for anybody wanting to have access to a firearms license in this country. And I did so, sir, because in my experience as a criminal lawyer prior to coming to government, I saw too many cases of persons whose mental stability was at issue. And in those circumstances, you were literally handing them tools that would destroy not just their lives, but the lives of those who were closest to them. Sir, there is no badge of honor in carrying a weapon that can kill somebody. And I pray that just as the executive is doing its part in creating a dedicated set of courts, 2 courts, one to deal with keeping current. Within 3 months, I've said to the minister, cases should be heard, and one to deal with reducing the backlog. We have already increased the penalties for firearm offenses in this country. What is needed, concomitant with the government's passage of this bill, is a clear recognition by the police of what is necessary to present a case in the shortest possible time before the court. Typically, the average gun case, and I'm sure the others who spoke before me will have addressed elements of this, doesn't have many witnesses, sir. It's not a complex case like a wounding or a murder case or even a drugs case or whatever. Invariably, it is the ballistics officer, the person who found the gun as a member of the law enforcement community, and possibly somebody to corroborate the evidence of the person who found the gun to establish chain of custody and various other things that are necessary to establish possession. And, sir, the accused, who may or may not avail themselves of the opportunity to speak, so that it defies rational expectation or understanding as to why those cases cannot be heard, quite frankly, in 4 weeks, 6 weeks. And we have seen from what transpired in the United Kingdom when there was an attempt by members of the society to destabilize that society and to engage in riotous activity, what is entirely possible. And I salute the British Prime Minister, who used his experience as a former Director of Public Prosecutions not to interfere in the process, because the separation of the judiciary and the executive is a well-established principle to which we all subscribe, but who used his position as leader of the government to bring everyone together and to ask them how can they act expeditiously to ensure that trials could be heard within a matter of days, one might even argue hours, because the days were so short. And that in some instances, within 72 and 96 hours, case done, person sentenced, matter fixed. And I'm not asking for the Usain Bolt type sprint on this occasion. but I would be happy for a 400-meter run, which is 4 to 6 weeks. And whatever the police need, and they've been told this, through their minister and directly through the National Security Council, whatever they need to be able to bring the case before the judge in the shortest possible time, and certainly not exceeding 3 months, but preferably 4 to 6 weeks, they will be given. Because every little boy and girl, every old boy and girl, every old auntie, grandmother, uncle, grandfather, everybody in this country must know that if you have a gun and you are caught with it, you will pay the price, and quickly so. And the time between when you saw the person being charged and when, if they are convicted, you see the conviction, will cause people to say, well, I can't play with this at all. I can't even be home for my birthday in 3 months' time. Or for my mother's 50th birthday. Or for my daughter's wedding. Or for some special activity. But the mentality has gotten into too many people that if you get catch, they ain't gonna do nothing about it in a hurry anyhow. And I would like you and others who make your money, sir, in representing persons, to recognize that your efforts will be required much sooner rather than later in the defense of the people whom you represent, so long as guns are involved. With a murder case, we accept that the complexity of evidence may not allow us to do that within 3 months. But I've equally said to the minister, as I did to the previous Attorney General, that there is no reason why every murder case should not be before the courts within 6 to 9 months at the High Court level, and that thereafter no appellate process should take longer than 4 to 6 months in each instance. And taken at its widest outer limit, that means that everything should finish within 21 months from charge to final appellate level, and potentially as quickly as 9 to 12 months. That is what the government is legislating for. That is what the government is providing the funds to achieve. And we've so managed our affairs in this economy that we have been able to do that. Increase the judges from 2 to 8 and now to 10. Increase the prosecutors by doubling the numbers. And I've just announced today that I will give them a unit of 3 persons to deal with backlog alone. And if after the review of 6 months we need temporarily to increase that further, we will do so. But starting with the priorities in accordance with the seriousness of the offenses, and at the same time looking at those where there is no victim, because where there is no victim, the issue for plea bargaining becomes almost that much easier and quicker to deal with. So, sir, I did not intend to speak for long today, but I felt that for this debate to take place without my voice, without my support, and as the Prime Minister who is responsible ultimately for signing off on judges, because one of the first things that I did was to dilute the power of a Prime Minister by allowing the passage of the Judicial Advisory Appointments Act, which allows our system to be far more transparent by having the judges of this country interviewed and having a panel that reflects the former Chief Justice, the former President of the Caribbean Court of Justice, a representative of the Bar Association, the current Chief Justice, I believe, and a member of civil society. Interview and recommend who should be appointed as judges in this country, sir. And that is the process we have adhered to since coming to office. I say to you, sir, that I expect their actions to be taken quickly, and that while I would have liked to have seen this 1 month ago, I am grateful nevertheless to have seen it now, and say to the minister, there is no dishonor in being second in a race, but I would prefer him to come first on the next occasion and deliver it within the 90 days that he had promised. We are close to 120 days at this point in time. Suffice it to say, however, that it is here, and that I look forward now to the Judicial Advisory Appointments Council acting with dispatch. I look forward to the police indicating what other resources they need to get the case files before the judges and the prosecutors as a matter of urgency. But above all else, I look forward to the people of Barbados recognizing and finding common purpose with us, as some of the artists have started to do. I listened to Master T's song, and he said, I can't call names, but on this occasion, I think that since I have forgiven the member for the city for being late, you will forgive me for calling this name. That mayor tell me put down the guns, so I going to walk up. I listened to Little Rick telling us clearly to telling the bad man to put down the guns. I've seen a song written by eminent Barbadian journalist Julian Rogers that speaks to Barbados being busy at 60, and being busy at 60 is fundamentally about us getting everyone online. Bajans Unite to Save Youth, BUSY. Whether that will have resonance with the artists is a matter for them, but if it does, like with everything else, we will partner with them, because the messages are mainly now for our teenagers who are being encouraged to participate in activity that can only lead to them having short lives, that can only lead to parents grieving, that can only lead to friends at school needing counseling, because the activities in which they are involved, there is no, or there is minimal buffer for recovery if their bodies are riddled with bullets. I appeal, Mr. Speaker, to every parent, regardless of your circumstances in life, to pay attention to what your children are doing. And for those children that you have that are over 18, I ask you to have some conversations with them and to reason with them while directing and guarding the ones under 18. Because, sir, there's no sense in crying. There's no sense in coming to beg for mercy. If your child is using guns and shooting people, then the full weight of the law. And in your instance, as a parent, I suspect that you may prefer the full weight of the law to be applied, because you can still go and visit them at Dodds. But for others who have received the other penalty, which is the riddling of their body with bullets, your only hope is to pull a picture from your phone or from your albums and remember mentally what the interaction used to be like. There is no buffer. And I end this debate by saying we are playing our part. I want every Bajan to get busy in this 60th year of independence, to help us work together to save our young people. But above all else, for us, if you know where guns are, and you know that the guns are there, as I said to the minister, the Honourable Minister, the member for the City of Bridgetown, they need to have a hotline that allows people to help, but we also have Crime Stoppers as well for those who prefer that. And the truth is that human intelligence always plays a role. Don't let anybody fool you. Even the ones who tell you, man, they're not doing that and that's respect, they all talk. They talk, if not to themselves, to their boyfriends and girlfriends, to their parents, to somebody, it comes out. And at some point, somebody is going to say to law enforcement or to somebody near law enforcement what they've seen, found, or heard. And at that point, what happens? The game is all over. So, Mr. Speaker, I commend the Honourable Minister for bringing it, albeit a few weeks late. I urge the Honourable Attorney General and the Minister, there are some other pieces of legislation that you will see come very quickly, and without offending the rules of this House, by announcing what they are, I say simply that there are a number of other bills that will come to this Honourable Chamber in quick order, as well as things that have to be done to better organize the functioning of the criminal courts through the establishment of new criminal procedure rules. I genuinely believe, sir, that the combination of actions being taken by us, when taken also similarly by the police and other law enforcement agencies, that we will see an appreciable change in how cases are handled. And I pray that as a result, that persons will end up recognizing that old good Bajan saying, that you can hide and buy land, but you can't hide and work it. At some point, somebody is going to see you holding the gun, or if you use it, somebody is going to trace it back to you. Let us apply our hearts to wisdom, and let us be good to this small island that has been good to us by ensuring that those things which can excite the greatest panic among our society are not allowed to take root here. And I start on this occasion with the issue of guns. There are other things that I will speak to as we go forward, but I want it to be very, very clear that this government is adamant and resolute that we will do everything possible to rid guns from our landscape, from those who are using them without proper license and without proper authority. The use of force is the sole prerogative of the law enforcement agencies in the state. No one else. These courts are being created to ensure that that will be the case. I'm obliged to you, sir.
Honourable St. James North.
Thank you very much, Mr. Speaker. I rise to lend my voice to this debate very briefly, but importantly, given what we're debating today, and within the context not just of our communities, but also within the context of ensuring that we can also, on the prevention side, ensure that our young people understand, one, the consequence of what we're passing or intending to pass today, but two, how do we now place it within the context of their lives and being productive citizens and staying away from not just the law courts, but staying away from a life of trouble and crime, particularly in circumstances where the prospects of the future of this country are bright. And I say so on the eve of our 60th independence, and therefore we must now ensure that these young people have the right attitudes and mindset to be able to navigate the world in which they live in. Mr. Speaker, you've heard throughout the course of this morning about the importance of ensuring that justice is not delayed. And I certainly want to echo that sentiment, particularly with respect to the number of communities and families that have been impacted as a result of crimes related to guns. There can be no place, and I repeat, there can be no place in our society for us to have a level of tolerance and indifference to what has been and continues to be a situation where people, and I don't just want to single out young people, where people in our country believe that they can have access to illegal firearms and bullets and can flaunt it, and there has crept up a pervading culture of persons going on social media and going wherever and brandishing firearms, thinking as if it's some Hollywood scenario. This reality must be confronted, and we have to therefore now, as a country, as I said, on the eve of a major year for us. Yes, every year of independence is important, but certainly 60 years must be a moment of pause. And I'm speaking not just to the young people, but to their parents, their families, their communities, and everyone who shapes their values and mindset, to help them to understand that going before a magistrate or a judge or before a jury for a gun crime, it is not a popular, it's not something that you should be reveling in and taking pride in. Oftentimes we look in our media, and our print media, television, and we see many of these young people being brought before the courts for these crimes. And their attitude is one of indifference and acting as if it is something that they should be parading. And I want to say, as I would have traversed my constituency over the weekend, as recent as this weekend, household after household would have been talking about how are we going to address the issue of these matters that we have. And most of the persons that I've interacted with, Mr. Speaker, I must confess, are happy about what we are doing as a government to be able to confront this issue. This amendment, no pun intended, is not a silver bullet, Mr. Speaker, but it seeks to be part of the overall strategy, particularly within the context of criminal justice reform, to be able to now give the authorities the power to do what is necessary to ensure that we can curb what we've been seeing. But I also want to very briefly use this moment, particularly as not just Minister with responsibility for education and education transformation, but as a father, to speak to the young men and young women in this country and to make a humble plea and to encourage them to, first of all, ask yourself, why have I been placed here on earth? Why am I here as a young person? And what is my purpose in life? And how do I use my skills and my talent and my God-given ability to be able to not only bring benefit and credit to yourself, but to your families and your communities, and by extension, your schools and your country. And if you have that conversation as a young person, whether you're in your teenage years, whether in your 20s and 30s, etc., Mr. Speaker, and you find that purpose, then that purpose will then begin to help you to drive in the direction, in a positive one, to be able to shape a brighter and more prosperous Barbados. And that, therefore, when you have that mindset, if we can have that at the community level across Barbados, what we will then see is a reduction in not just crime, in the attractiveness of crime. Now, why am I framing it in this way? Because young people and people who end up before the courts don't just get there because they wake up one morning and say, I want to be involved in crime. There are a number of sociological and underpinnings, and Mr. Speaker, notwithstanding, of course, your background in the law. I know your background is also steeped in sociology and social sector. And one of the things that you would appreciate is that when you dig deep into a lot of the issues that are underlying why many of our people are ending up before the law courts for guns, it is oftentimes, yes, influenced by bad behavior, peer pressure, but sometimes the absence and a lack of a presence of a father figure or a strong figure in your family who can guide you in the path that will help you to stay away from the court. And it is for that reason I want to, first of all, thank all of the persons in Barbados who have hitherto answered and heeded the call of the Ministry of Education Transformation, where we've asked for volunteers, but in particular, male volunteers to come and work with us in helping us to shape the minds of our young men in Barbados. And this is important for a number of reasons. And part of it is, and it's not just only to the men, because there are women in our country who have given and will continue to give strong leadership and guidance to our young people, both male and female. We've seen it throughout the years in the Scouts, Cub Scouts and Scouts, and Brownies and Guides. But as you may recall, in September of this year, Mr. Speaker, for the first time we're introducing at the formal level the mandatory component of our curriculum, where students must now, in order to complete their secondary education in Barbados, 60 hours at 60, to ensure that they have the understanding of what it is to be civic-minded, community-minded, working with their peers, and therefore they will be required to either enter a civic-based organization, a uniform-based organization, or a team sport, thus allowing him now to change the behavior. And it is not intended, Mr. Speaker, simply to, as it were, curb behavior. There are young people in our country who are on the right path, good grades, doing everything that you would want in a model citizen. But having the qualifications alone coming from school, but you're not having the right mindset in terms of how do you shape a nation, how do you work with your colleagues, how do you have empathy, how do you handle conflict in a wholesome way, we will be doing an injustice to our people. And therefore it is intended to ensure that as we prepare for the next 60 years of our development as a nation, we give our young people the tools and attitudes and values and discipline to be able to navigate life long after they have left school, but in so doing, giving pride to us as a people. So I want to use this occasion to once again encourage and invite persons around Barbados, whether you're retired or you want to give back a few hours of your time to a country that has given so much to you, to work with the Ministry of Education in being able to volunteer for our community service learning initiative, which will be rolled out in September of this year, Mr. Speaker. And I want to commend the Honourable Member for the City, who, of course, has brought this here this morning, and I also want to commend the Honourable Member for Christchurch East, both of whom have worked tirelessly, Mr. Speaker, to ensure that we can have this framework to address an issue that this country is facing. But one of the things that we have never done as a people, Mr. Speaker, in Barbados, is to run from difficult moments. Difficult moments throughout the last 60 years. There are examples which have led us to know and be persuaded that we have the ability to face anything head on. So yes, we're looking to have the gun court, as it were. But there's also the prevention side, that not just the Ministry of Education or the Ministry of Social Empowerment, Mr. Speaker, but the communities and the churches and the spiritual-based organizations must work hand in hand to ensure that we can be also on the preventative side. But if you determine that you want to test faith, you also understand that the legislation is there and very, very clear as to what consequence will ensue should you believe that that is the direction that you want to go in. And with those few words, Mr. Speaker, I want to unreservedly support this bill and this amendment. I thank you.
Member. Honourable Member St. Michael West Central.
Thank you, Mr. Speaker. I too will be very brief, but I would not have allowed this opportunity to go unnoticed, and certainly without having an opportunity not only to thank the honourable member for the City of Bridgetown for laying this bill and, of course, presenting the bill this morning to this honourable chamber. Mr. Speaker, the Supreme Court of Judicature bill effectively paves the way for what I would consider to be the continued effective management of the justice system in Barbados. And I say so, Mr. Speaker, because when you seek and when you look at the bill and the intent of the bill, it really puts it into its context, its proper context, when it says that it sets out to increase the number of judges. And in doing so, Mr. Speaker, in setting out to increase the number of judges, it tells us that the government is, of course, on track, that the government understands that it has to be very responsive, as we've heard from the Prime Minister not so long ago. It also makes the point that if we are to continue to arrest the situation as we are arresting the situation, then we have not only to speed up the process of justice in Barbados, and therefore, by increasing the number of judges that we are going to appoint, will certainly go a long way. Mr. Speaker, I have long argued that Barbados has always been a leader in the orderly development of a country. And I subscribe, Mr. Speaker, to the orderly development of a society as well. And therefore, if we want to maintain the orderly affairs in this country, we have to do so by being responsive, and we have to ensure that we give not only the police and the judiciary the necessary tools that would certainly help them to execute their mandate. Mr. Speaker, the establishment as well of a firearms division is most welcome. It is a timely response to what is happening in Barbados, and I also would have to commend the honourable member again for the city for his foresight in ensuring that we have a firearms division. Some people refer to it as the gun court, Mr. Speaker, and it cannot be understated that based on what is happening in our society, based on what is happening certainly in the communities, that we have to ensure that we speed up justice, and this again is another wonderful opportunity for us to execute that mandate. The impact of gun violence in our communities must not be allowed to continue, and I'm very pleased and thankful, and I go on record thanking the Barbados Police Service for the outstanding job that they do in apprehending those who are involved in gun violence and other criminal activity. Were it not for them, Mr. Speaker, Barbados could not have maintained law and order. And the fact that the Prime Minister made the point so clearly this morning that whatever the police ask for, of course, they will get. And she made it very clear here, I think is an important factor that we have to bear, and certainly the society would appreciate the efforts that are being made by this government to not only arrest and to reduce criminal activity in Barbados, but to the extent where we have a situation where guns are coming into a country, we are taking the appropriate policy measures to address the inflows and, of course, to reduce those guns coming into our country. Mr. Speaker, we have seen what gun violence can do in our communities. My community, for example, is not without an infraction in that respect in terms of what people would wish to do, and therefore we believe in life, we believe in liberty, and I'm a firm believer that people, particularly in communities, must be allowed not only to conduct their businesses, but they must also be allowed to go and to do what they like to do within a community without the fear of being subject to any gun violence. The legislative agenda of this Barbados Labour Party, again, must be commended. We have been very responsive. Only 2 weeks ago, we came to this very place and we debated the Criminal Gangs Prevention and Control Bill. And that was 2 weeks ago. And we're here again today, now debating the Supreme Court of Judicature Bill. Mr. Speaker, the other measures taken by the government, not only in terms of legislative actions, but also the support for crime prevention must be lauded, including, Mr. Speaker, our ports of entry, where the government since 2018 would have spent over $20 million upgrading the security apparatus at our port of entry. We also have, of course, the continued support and investment and, within the national security framework to ensure that we maintain law and order, including, of course, technology that we're seeing when we move across the highways. That, Mr. Speaker, sends the correct signal to the community. It sends the correct signal to let people know that the government is out there working hard, is taking a very judicious approach to how we deal with the issues of violence within our society, but that we also understand the critical importance of ensuring that we continue to maintain safety in Barbados. The facilitation of the legislative agenda is absolutely necessary, and certainly I would wish to reiterate, make the same appeal that I made when I spoke 2 weeks ago on the Criminal Gang Prevention and Control Bill, where I asked the Honourable Member for the City of Bridgetown to consider public education. And I would reiterate that call today for the call for public education with respect to not only criminal gangs, but also what we're doing here today with respect to the issue, addressing the issue in another but judicial way, the matter of guns within our society. Mr. Speaker, I think it's important if we let the young people know, and others as well, the seriousness of having a license for an arm, if we let them know the penalties that they're likely to face, if we let them know if you harbor people who have these violent means of dealing with societies, that they too would also be caused to fall into a predicament that they would not wish to be in. And I, again, will ask that the public education be done utilizing social media as well. A lot of young people are focusing on social media. A lot of people sometimes don't read as much as they ought to read, but the visual and the pictorial, I think, will go a long way in sensitizing, especially those who are coming through our education system, those who are obviously aware. But it would also, and the Prime Minister touched on this point, would also sensitize parents and grandparents and other relatives. And once you sensitize them, people understand. It's not oftentimes, Mr. Speaker, that individuals will pick up and read an act as we do here, because it is our duty when we come to this honourable chamber. But if we can break it down in such a way that we present the facts too in a very simple but effective way, I think it will go a long way, Mr. Speaker, in assisting not only with the reduction, but also with the understanding as it relates to criminal activity in Barbados. Mr. Speaker, I hope that, and of course, as part of my portfolio, I'm responsible for tourism. Again, I commend the Minister, Honourable Member for the City of Bridgetown. I also want to say that to all, not only the persons within my constituents and the community at large, but certainly to the stakeholders in Barbados, and particularly those stakeholders within the tourism sector, that you're seeing what a responsive government is doing. We are making the resources available to the police across security. We are also bringing the appropriate legislative actions that are required, but we are also supporting with the human resource element, that is the staffing and other resources that are those resources that are required to ensure that we continue to maintain law and order. I reiterate, Mr. Speaker, that because it's important, because oftentimes we have to ensure that whenever matters are put into the public debate with respect, or the public domain with respect to debates on what violence can do to society, we also have to be mindful, Mr. Speaker, that this country also relies very heavily on tourism, and the fact that we are taking very strategic, very critical, very strategic, very steady, but also very critical responses to how we manage. We're not doing it in a very cavalier manner. It's being done in a very calculated, very strategic way. And as you see the legislative agenda coming before this Honourable Chamber, we see the other resources being allocated. I want to send a very clear signal that this government obviously is doing what it is entrusted to do, and that is to ensure that we protect the citizens and, of course, visitors who come to this country. Mr. Speaker, I did indicate that I would not be, I would detain the House unduly, but I really felt it necessary not only to speak on this matter in relation to not only a community, a constituency, but also to a country that depends very heavily on tourism. Mr. Speaker, I know that the work of the Barbados Police Service, I know the work of the other security forces, and I really want to thank the member of the City for Bridgetown again for obviously his leadership in trying to contain the situation, but also doing what he's entrusted to do, and that is to help us to maintain public safety in Barbados. Mr. Speaker, with those few words, I'm obliged.
Honourable Member for St. Michael Central.
Mr. Speaker, sir, I rise to lend my support to this bill, the Supreme Court of Judicature Amendment Bill 2026. It is important that I lend my voice in this debate because, as you know, I represent a constituency that has been gravely affected by gun crime, gun violence. When a shooting happens, two families mourn. I always say that. On one side, you have the shooter's family, who now has to be embarrassed, who has to go to court and spend lots of money, who has to take lots of trips now to the prison and have to hold their head in grief because of something that their child, their brother, their uncle did. And then on the other side, you have the victim's family. The victim who, if not deceased, may be gravely disfigured, may be in critical condition. And as such, when these type of situations happen, no one really wins. No one wins. And it's a sad situation because when you pull out a gun, there's only one thing you could want to do there. Because at the end of the day, a gun is a weapon of mass destruction. It is not a toy thing, it's not a play thing. And I think the young people need to understand this. Because we live in a society now where we're playing video games. And you might shoot a man, and then he teleports and enters the game again. So young people, some young people may not know the gravity of their actions when they pull out a gun. Some young men use guns to try to impress women, try to impress females. So females have a part to play in this too. If you know someone is close to you who has an illegal firearm, it is your duty to report that to the police service. Because we have to get these guns off of the streets of Barbados. Barbados is too small to have so many guns in these streets. But we also need to tackle the issue of how they're getting into this country, Mr. Speaker, sir. We need to look at that, and we need to look at that very seriously as a government. Because at the end of the day, guns are not manufactured in Barbados. So we need to go a step further as well and get these guns off of the streets of Barbados. At the end of the day, crime affects us gravely. You heard my colleague speak of it just now. We are a country whose economy relies heavily on tourism. And there will come a day that if this continues in the trajectory that it is going, we may be blacklisted as a country. We don't want that, Mr. Speaker, sir. How many jobs are being created based off of tourism? The hotels, the Airbnbs, the service providers, whether it's lash techs, nail techs, hair salons, even the simple man on the beach that sells the aloe vera or sells a massage with the aloe vera. Imagine he can't make any money now because persons are not coming to this country anymore. We want to prevent a situation like that, Mr. Speaker, sir. And at the end of the day, we're not like Trinidad that has its stand your ground legislation, where we're allowed as innocent civilians to have guns in our homes to protect ourselves. So we have to protect the innocent civilians in Barbados by ensuring that the other side of things, which is the criminals out there, don't have these weapons of mass destruction. Mr. Speaker, sir, police officers as well need to be recognized. When they go out there and they're facing sometimes persons who have bigger guns than they do, imagine what situation they're put in when they have to put their life at risk in order to keep these streets safe, Mr. Speaker, sir. So we have to take these weapons of mass destruction away from these criminals. Also, I must applaud the honourable member of the city for bringing this bill to this parliament, because as you heard, it creates a gun corps or a firearms division, allowing for there to be a more speedy trial. Because we had a Bail Amendment Act which says unless there are circumstances like there's not enough evidence and things like that, you have to spend, I believe, is a minimum period of 2 years in prison before you can get bail. But sometimes what happens is these trials take so long that persons get bail, they come out, and then they go and commit similar crimes. And they find guns, even though the gun that they used for the crime before was confiscated, they find another gun somewhere. And they go and create similar crimes. So I commend this bill because what it is doing now, it is serving justice in a timely manner. It is limiting the possibility of reoffending. And as such, it is keeping us as Barbadians safer, Mr. Speaker, sir. At the end of the day, guns, as I said before, is nothing to play with. It is serious. It needs to be stopped. This gun play, this gun war, it is just continuing. It is a cycle. I kill you, and then your family wants to kill me, and then my family wants to kill you for killing me, and it goes on and goes on just like that. I personally have been affected by this too, Mr. Speaker. I've lost constituents, I've lost friends, I've lost family to gun crime. I've lost them all, so I know personally how it feels. And it's something that happens so sudden, because at the end of the day, when you squeeze that trigger, you don't know the direction the bullet is going to go. And sometimes innocent bystanders get hurt, because a lot of these shooters are not trained shooters. So when they're out there shooting, they're shooting wildly, and oftentimes they sometimes even miss their target, but they hit someone who was simply there, wrong place, wrong time. And so with all of these things, Mr. Speaker, sir, I commend this legislation, I support it, and I believe we as a government ought to support it. It is once again another step we as a government, we are taking to ensure that the streets of Barbados are kept safe. So, Mr. Speaker, sir, my contribution was very, very short. So with these few words, I am obliged.
Honourable St. Michael for Christchurch East Central.
Thank you very much, Mr. Speaker. I too will be short. But this debate, it reminds me, sir, of about 30 years ago when a famous band in Barbados, Spice and Company, sir, spoke about too many guns in Barbados. And around that time, sir, many of our Calypsonians put pen to paper to reflect on what was happening in the country. And indeed, the government responded, and you will recall, sir, there was a tagline, "Arm the police, sir, the violence will cease." And to the extent that we, as a country, still was investing in education, sir, still providing opportunities for our young people, we've arrived here today because of, in part, since that time, we've seen a proliferation of shootings across North America, and the extent to which the region is paying the price for the Second Amendment in the United States, sir, is significant. And to the extent that I have responsibility, sir, for customs and the border, this government, we have put a number of systems in place, sir, to beef up the surveillance, the security. But you and I both know, sir, in the same way that we are asking Barbadians to do something about the circumstances in which we are faced, we must now accept that whilst we are asking ordinary citizens to be in the fight, sir, the government has put measures in place at the border, not just with customs, but with the port workers, all of the people involved in clearing items coming into the country. That we too, sir, must stand in the breach to make sure that we work in the best interest of Barbados. Now, sir, if you and I are two customs officers or two port workers or two people in a warehouse, sir, handling goods and processing in the country, but you and I, sir, have a different motivation than what we are asking the citizens to be able to step up and respond, then we're going to have problems, sir. And therefore, the government continues to put not just financial resources, not just to get equipment in place, sir, to ensure that those famous calypsos that we all dance to, sir, and we remember and regale, that we now must emphasize that with the establishment of these gun courts, in the same way, sir, that when people are shot and they are rushed to the Kuwait, sir, because it always amazes me how people just find Martindale's road fast, sir, to be put ahead of people who are genuinely ill and waiting for treatment, that this gun court now is going to fast track and to make sure that justice in this country can be done and done swiftly. And this is not in any stretch of imagination, sir, to say that we are going to run roughshod over anybody's rights, because I think that must be made very clear. We are asking the police to do their job. They've done their job. We are asking them to do the processing quickly so that citizens can have confidence from start to finish that if anybody does anything in this country that is not what we want, this is the new standard within which we're going to deal with these matters. In the same way, sir, that if I fall ill and the ambulance has to come and collect me and take me to A&E, we expect a certain standard with respect to treatment of care there. This is what we are saying. The government is now setting a new standard with respect to how these things will be treated. And it is important, sir, because notwithstanding the trauma, when people see people walking about in the community, sir, who have done things and they've seen these things happen, that now becomes learned behavior for other people to say, well, I could do something too, because they ain't coming for me no time soon. And therefore, we must change that narrative completely. And therefore, I support the establishment of not just the court. We've voted money in the budget, sir, to make sure that once the judges are appointed, the staff are hired, that these things can roll on immediately so that we can start to address these matters, sir, frontally. People want justice, sir. They really, really, really want justice. And in this instance, whilst justice is not going to solve in the context of putting a little more love in people's hearts, because I think fundamentally, sir, that is what is completely missing from what we are witnessing in the society today. People want justice, and they want to know that the government is doing what it must to deliver it. And I'm asking whoever is the judges, sir, or the magistrates, or whoever is involved in this particular process, that they must treat these courts, sir, as a place of serious business. And in the same way that we are asking the doctors at the QEH to treat us when we go there, sir, the officers, public officials involved in this must treat this with the same seriousness as we are asking the people at the border to treat the security of the country. And therefore, as we are pressing on our side to make sure that we beef up the security at the border, when cases come before these courts, sir, they must be treated with the reverence, the importance within the entire puzzle piece. And this is critical, sir, for, I think, allowing us to be able to, over time, show our citizens that we can respond in the way that we can respond whilst we deal with the programming in our community, sir, to be able to ensure then that not just the Ministry of Education can do their work because they have their they're teaching to do. And if the Ministry of Education can't have settled schools with settled minds, then the long-term future of this country will not be assured in the way that we want it to be assured, sir. And therefore, this government has been faithful, not just with the legislation, but the provision of resources. And the reality is, sir, that we understand why this is important. And the fact that we've come here, we've already voted the money, we are putting this legislation in place, is off now to the I suppose, the Judicial Commission or whoever to get the judges in place. And so as we will pass this, it is over to the administration then to make sure then that we get the right people, the right systems, the digital things in place to allow not just the police, but the entire ecosystem to work in the way that we want it to work. But the government, sir, is absolutely committed to ensuring that we can, from A to Z, make sure that we dot our I's, cross our T's, sir. And I say to Barbadians, if you know that you're going to get involved in these types of things, then this is the ramification. But the reality is that we're not having to spend money to do these things when we really should be spending money, sir, to open opportunities for young people. And I know that the member for St. Thomas is doing his work on the other side to make sure that with respect to the diversion away from the criminal justice system, that work will continue, sir. Because as we are doing this, we must ensure that we push and press to make sure then that we can move as many people, young people, away from the criminal justice system. And that is why, sir, I will repeat, whether it is the trust loan program that we've put in place, sir, to help young people start businesses. I know the Ministry of Agriculture has been putting measures in place with respect to the feed program to give opportunities for young people to get involved in agriculture. The Ministry of Energy and Business, my honourable friend here from St. James South have been busy training a mob ton of young people in construction, gateway, hospitality to match the jobs that are currently available, and we're trying to get more people trained up to take advantage of these opportunities, sir. There are opportunities for young people in Barbados, sir. And therefore, we will not rest, sir, until we can train everybody as fast as we can, given the capacity that we have. And therefore, we're asking all Barbadians, sir, to not just steer these young people away from the criminal justice system, but I would love to be able to, that once we solve the backlog of the courts that we have now, sir, I would like that we are not adding any current cases, sir, for the next couple of years, because we've been able to move the minds of our young people away from this so that the Ministry of Training can be asking me for a little more money, sir, to be able to do more training, because we are seeing those results. And that the Minister for Home Affairs, sir, that he's telling me that we no longer need all this accommodation, because the Ministry of Training has taken out all the young people, and therefore we've been able to divert those very critical resources. And therefore, whilst we are doing this, we will continue to strive and press for the retraining of our young people to ensure that the actual opportunities that are here in Barbados, that they see them and that they know how they can be able to take full advantage of those opportunities. And with that, sir, I support this bill, and I say to the Minister, do your work, and the rest of us will make sure that we guide our people to make sure that we get this done. And with those very few words, sir, I'm obliged to you.
Honourable St. Thomas.
Mr. Speaker, thank you for the opportunity to participate in the debate on this bill. Sir, I was very happy when the Honourable Member for the City began the work to bring this manifesto pledge of the government into fruition. A lot of people call it a gun court, but sir, I believe that the appropriate recognition that this is a firearms division of our existing High Court becomes the predominant consideration. The firearms division now extends the capacity of our judicial system to address what is really an emergent crisis if we allowed it not to be able to
platform.
if he allowed it to continue as is. So when I came to the bar, there were 2 judges in the assizes. And by 2018, there were still 2 judges in the criminal assizes. We have expanded that to meet the needs of the criminal justice system. But what we're doing here today is not only expanding the number of judges available, but we're creating a specialized court. And that is what is going to be the most important and decisive factor in determining whether or not we are meeting our targets. You see, sir, we can speak about the fast reduction in firearms cases as one of the primary objectives. I believe that the court, with 2 judges dealing with firearms cases, would allow for a faster prosecution of the gun crimes and gun-related crimes in Barbados. It would also reduce the backlog of those gun crimes and provides the public with greater confidence that the serious offenses that are affecting the community are being dealt with, and that is the commitment of the government. But what is also equally important, sir, is that the firearm offenses being dealt with by a division of the High Court would improve the accountability of the judicial sector, the justice sector, for dealing with violent crime. Firearm offenses are linked to shootings and gang activity, and we passed legislation 2 weeks ago to deal with that, but also armed robbery and organized criminal networks. A gun court will be served by police, who will now be able to increase their knowledge in ballistics evidence, digital and forensic evidence that will be able to solve some of the more complex cases and the criminal enterprises that are invading this country, especially putting the guns in the hands of the young people. And it takes a level of speciality in those areas of ballistics and forensics to be able to prove the necessary ingredients of the gun offenses. But we need more specialists in that area, and having a specialist judge or judges trained in ballistics and forensics dealing with those matters will help with the accountability and improve the accountability of the justice sector. It also improves the public confidence in our system when citizens can feel that the government is responding by putting institutions and structures in place to deal with what is a pervasive problem. And we can also feel that the police themselves, having to investigate these crimes, sir, and having to prosecute these offenders, can start to break the back of what is really a serious social problem. On the other hand, sir, we will know that we have, on the penal side, how do we deal with those persons who are convicted? It will mean, sir, that there may be a potential for increased admissions into the prisons. How we deal with the sentencing options that are available in these gun crimes. We have increased the sentences in recent times for gun-related offenses. How do we deal with these situations? It will mean increased admissions and longer average periods of incarceration for firearm offenders. So government is looking at a system of parole to introduce it into the mix of options for sentencing in Barbados. We are currently having a discussion at a symposium celebrating the 80th anniversary of the Barbados Probation Service, which celebrates 80 years this year. And that symposium, sir, speaks to enhancing the options for sentencing and penal system reform. And one of the key components, sir, is how do we introduce a system of parole alongside a probation system that has existed for 80 years into Barbados. I just left a discussion on parole. How long should it be before you are entitled to parole? Should the sentencing judge determine that parole is not an option for an offender who has been convicted? Should the state apparatus dealing with parole, the parole board, be the sole determinator
as to whether or not a person is eligible for parole, and should Parliament draw the balance between the judges who sentence and the parole board which would administer parole. These are the considerations that are actively engaging the Ministry of Home Affairs, sir, and the Barbados Probation Department and its partners across the sector. Judges are there, magistrates are there, lawyers, members of the DPP, and the social agencies within the probation department, the welfare department, the social empowerment agencies, and all the other NGO community who help within the sector are all putting their brains and minds together, sir, to hammer out a system that responds effectively to what we have going on in the country. A lot of the institutions that we have had in Barbados, the probation department has been around for 80 years, but that too has outgrown the legislative scaffold that it has been built upon. The department does more than what the legislation says. The Probation of Offenders Bill does not limit what the department does. The department does a lot more. And we are contemplating, sir, adding parole as a new function to be administered by the probation department. So it needs, therefore, for us to have more discussions on the rehabilitation programs within the system. Long sentences are warranted for the most serious and egregious criminal offenses. That is a fact. But at the same time, for justice to be effective, we have to inquire as to what are the circumstances that brings the offender before the court in the first place. Because if we only look at punishment and retribution and focus little on rehabilitation and the eventual reintegration into society, then we are not necessarily breaking the cycle of recidivism, which the numbers suggest, which the statistics suggest, is one of the biggest contributors to the pervasive nature of gun crime in the country. Too many people who are before the courts, and the numbers tell us this, have had family connections who have been convicted and incarcerated. Alarming numbers, sir. There's a great correlation there. Too many offenders who are before the court have either been using illegal substances or alcohol. And a large amount of them have used illegal substances prior to the commission of the offense itself for which they have been convicted. And there's a correlation there. We can also look at the statistics and see, go far back and see that some of these offenders who have been convicted have had early childhood traumatic experiences. Sexual abuse, verbal, physical, emotional abuse, neglect, starvation, deprivation, broken families, no supervision, absenteeism at school, associating with unsavory characters in the community, people who have been groomed from ages even before 11. They start out, sir, as youngsters on the block, scoping to see when the police and the authorities or other persons that threaten the environment approach. They move and graduate to stashing illicit items, guns, stolen merchandise, then to petty crimes, preying on people who might necessarily appear more vulnerable. And then they graduate to the more serious offenses at very young ages. This is what the statistics are telling us. And therefore, we recognize as a government that as we pass legislation like this into law, it requires a concomitant approach to ensuring that the functions of the firearms division of the court will lend to the objectives and the outcomes that we want to produce. That is justice and fairness in the society, not only for the perpetrators of the crime, but for the society overall. We understand, therefore, that it is incumbent upon us as a government
to put the necessary resources to ensure that departments like the probation department are properly staffed. They are undergoing a restructuring. Indeed, in recent times, they have had an increase in the number of probation officers available to them because we know that the increase in the court system in terms of the amount of judges will require a concomitant increase in the number of probation officers. We also know that once we put the parole system in place, we would have to have adequate staffing, and that is being addressed as we speak. So, sir, even on the side of the prison officers, we are also looking at restructuring there, and that will come. I don't want to give the country and the House the assurance that we too are working to ensure that our system for the administration of justice and in dealing with one of Barbados' biggest challenges, that is the pervasive elements of gun crimes, are adequately dealt with to the satisfaction and the benefit of the people of Barbados. And sir, I thank you for the opportunity.
Honourable City of Bristol.
Speaker, I raised to wrap up this debate on this bill, sir. But before I proceed, sir, I know, sir, that the Honourable Prime Minister and the Attorney General and myself, sir, we were invited by the British High Commission to celebrate the 10th anniversary of the Fusion Centre, sir. And I really want to humbly apologize publicly, sir, for our absence, because, sir, of our commitments today in this chamber, sir. Sir, I want to thank all contributors, sir, to this debate, sir. Of course, the Honourable Prime Minister, sir, in her statement, sir, in her presentation, she said, sir, that justice, when delivered quickly, sir, is the best form of crime prevention, sir. And that is indeed, sir, a very serious statement, sir, and a statement, sir, that is embedded, sir, in this legislation before, in this bill, sir, before this chamber, sir. We know, sir, that the issue of backlogs is really a problem, sir, not only in Barbados, sir, but in other countries, sir, that they have to grapple with, sir. And for the first time, sir, in the piece of intended legislation, sir, before chambers, sir. And when they look at this bill, sir, at section 27, sir, sorry, section 28, 1, sir, the language that is used, sir, in this section, sir, and it states, a magistrate before whom any case involving a firearm is brought shall, sir, forthwith transfer such case for trial by the firearms court, sir. I mean, sir, I have never seen anything like this in any piece of legislation that I've come across in my practice, sir, or being in Parliament, sir. But this, sir, mandates the magistrate, without delay, without any adjournment, sir, to transfer the case immediately to the High Court, sir. That means, sir, application for bail, and also means trial, sir. Trial. So I think that this is revolutionary with respect to legislation, sir, coming here, impacting on the criminal justice system, sir. We know, sir, that speedy trials, as mentioned before, speedy trials are as a deterrent for offenders and for persons who intend to get involved in criminal offenses, sir. We know, sir, that there will be attempts and there will be moves by this administration, sir, further moves to remove the backlog of cases within the criminal justice system, sir. I am of the view, sir, that there are certain offenses, sir, that should not clog up the High Court, sir. Indecent assault, sir. It really should be dealt with by a magistrate, or if you want to do it hybrid, sir. I also believe, sir, escaping custody some of those matters go before the High Court, sir. Those matters should be dealt with at the magistrate level and gotten rid of off the books, sir. I also believe too, sir, that as soon as you appear before the magistrate, sir, and you give an intention that you want to plead guilty, sir, that the probation officer should start the pre-sentence report from there, rather than waiting up to High Court to prepare a pre-sentence report, sir. So you won't have to wait a long time to get a pre-sentence report, sir. That is my view, sir. I saw one magistrate do it, sir, because I insisted as counsel, given the age of the offender, that we start the pre-sentence report as soon as that person gives the indication to the court that he wants to take an early guilty plea, then prepare the pre-sentence report. So those are some of the things we have to look at, sir. The fact too that the criminal procedure rules is coming, sir, but then place the obligation on the state and on the defense counsel, sir, to ensure that they are case ready. When you say case ready, sir, that they are ready to proceed to trial, and that the prosecution is ready, and that the defense is ready, because we need swift justice, sir. Further, sir, I agree, sir, too, with one honourable member who said that we should engage in public education. And very shortly, sir, my ministry will be going out with some public service announcements on all the pieces of legislation that's been passed in this chamber, sir, that impact on the criminal justice system, sir. We will utilize entertainers, sir. And the Honourable Prime Minister mentioned Master T. But I like Master T too. I listened to him the whole of Saturday night, sir. I like Master T. I love lyric song too, sir. And we must also engage the social media influencers, sir, that can reach people and that can reach young people, sir, with the messages, sir, that we must tell our young people that stay away from the firearms, sir. Keep out the courts, sir. Keep out the, before it was White Park Road, sir, keep out the Corey Street, sir. Keep out the Corey Street. And so, you know, this debate, sir, not only provides an opportunity, sir, for us to speak to the public about what we are doing in terms of crime prevention and what we are doing from the legislative point of view, but indeed, sir, the Honourable Prime Minister mentioned, look, I want to see a unit in the DPP department, sir, to deal with the backlog, sir. That is indeed a wonderful concept, sir, a wonderful idea, sir. Because they have to deal with the existing trials, not only at High Court, not only at CCJ, sir, but also the Court of Appeal too, sir. So if we need additional staff, then we will do that, sir. The fact too, sir, that the police need the tools to fight this crime. Whether it is increasing their drone capacity, increasing the scanners, sir, at the ports of entry, sir, all those things, sir, we will do, sir, to ensure, sir, that the public of Barbados is safe, sir. Sir, my friend from St. Thomas, the member of St. Thomas, sir, did speak, sir, to rehabilitation of offenders, sir. We cannot, sir. We cannot leave out, sir, or turn a blind eye, sir, to rehabilitation of offenders, sir. Persons who, especially first-time offenders, sir. First-time offenders, sir, we have to treat very carefully. Because we are placing them, sir, in the same facility, sir, of hardened criminals, to rub shoulders with hardened criminals. And we must do whatever is possible, sir, to enhance the programs at the prison and to ensure, sir, that they get instructions and that they get the necessary programs, sir. Some, sir, might be through drug dependency, sir, substance abuse. And, sir, I have no objections, sir. And in fact, sir, I'll be advocating also that we reestablish the drug court, sir. Because some of these crimes too, gun-related crimes too, sir, is a result, sir, of substance abuse and drug dependency, sir. Sir, I believe I have touched everything, sir, thus far, sir. So, sir, in the circumstances, sir, Mr. Speaker, sir, I beg to move that this bill be read a second time, sir.
The question is that this bill be read a second time. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, sir, I beg that you do not leave the chair and the House resolve itself in committee for further consideration of this bill, sir.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
This Honourable House is now in committee.
Clause 1.
I beg to move that clause 1 stand part.
The question is that Clause 1 stand part. All honourable members in favour, say aye. Honourable members against, say no. I think the ayes have it.
Clause 2.
I beg to move that clause 2 stand part.
You beg to second that, sir?
The question is that Clause 2 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 3.
I beg to move that clause 3 stand part.
You beg to second that, sir?
The question is that Clause 3 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 4.
I beg to move that clause 4 stand part.
You beg to second that, sir?
The question is that Clause 4 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 5.
I beg to move that clause 5 stand part.
Sir?
The question is that Clause 5 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Report.
Mr. Chairman, I beg to move that you report to the Honourable Speaker the passing of one bill in committee.
You beg to second that, sir?
The question is that I do now report to His Honour the Speaker the passing of one bill in committee. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Chairman of Committees has reported the passing of one bill in committee. Honourable Member City of Bridgetown.
I beg to move that this bill be now read a third time.
Beg to second that, sir?
The question is that this bill be read a third time. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg that this bill be now passed and cited as the Supreme Court of Judicature Act, Amendment Act 2026.
The question is that this bill be passed and so cited. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it. This bill is passed and so cited.
Recommittal papers, sir.
Honourable Member for Christchurch East.
Mr. Speaker, I beg to lay the ILO Convention 152, Occupational Safe and Healthy Work Convention 1979. I beg to move as well to lay, sir, the recommendation number 160, the Occupational Health and Safety Work Recommendation number 160 of 1979. Beg to move to lay the Convention 159, Vocational Rehabilitation and Employment Disabled Persons Convention number 159 of 1983, and beg to lay recommendation 168, which is the Vocational Rehabilitation and Employment of Disabled Persons recommendation 168 of 1983.
Government business.
Government business is the order of the day.
Mr. Speaker, with
Honourable
that,
Member Christchurch East.
sorry, Mr. Speaker, with that, we've come to the end of today's sitting, I beg to move the adjournment of this honorable chamber until next Tuesday, the 16th at 10 in the forenoon.
The question, the question that this honorable chamber be adjourned until Tuesday, the 16th day of June, 2026 at 10 a.m. in the forenoon. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it. This honorable chamber stands adjourned until Tuesday, the 16th day of June, 2026 at 10 a.m. in the forenoon.